Okay, we're going to begin with a prayer. The Lord be with you. Let us pray. Gracious and loving God, we give thanks for this day and all of its beauty and wonder. We give thanks for this time together to discuss and reflect. And we pray that you would open our hearts and our minds as we think about the issue of affirmative action and our role in creating a more just society. All this we pray in the name of Jesus Christ. Amen. Well, we are blessed today to have an expert in this important topic of affirmative action. He's going to speak with us as well about some pending cases before the Supreme Court. So we have Dr. Kim Forde-Mazrui with us, who is a professor of law at UVA and specializes in these topics. So Kim, I thought we would start off with a general question, just to make sure we're all on the same page. What is affirmative action? How do you define
it? Sure.
I think that's on here.
That's on. Okay. First of all, thank you very much for having me here and being here to discuss this very important topic. Conventionally, people think of affirmative action as the use of race in college admissions. I think of affirmative action in a broader sense, which is taking affirmative, proactive action to try and correct for racial inequality. So after the overthrow of segregation in the 1960s, many people hoped that racial equality would be achieved. But discrimination over many generations has left significant disparities across all social and economic indicators between races, especially black and white. And stopping discrimination was necessary but insufficient to close that racial gap. So affirmative action is taking more affirmative means than just stopping discrimination to try and achieve actual racial equality. So then the use of race in college admissions is just one example of affirmative action and one that gets the most controversy both in politics and in the courts. So that manifests itself in universities, especially public universities, which is what the Constitution applies to, taking account of race as a plus factor in admitting underrepresented racial minorities, especially Black, Latino, and tribal Indian.
Two questions. Does UVA use affirmative action for admission? And then what are some of the other ways in which affirmative action plays out in our society beyond college admissions?
Yeah, I'm pretty certain that UVA does. I haven't actually asked them. It's not something I think people like to talk about because potentially can result in being sued. But I know we're publicly committed to diversity, so I'm confident that we are using race in the manner that the Supreme Court has allowed.
And what are some of the other ways in which affirmative action plays out in our society? What other sort of programs exist beyond college admissions?
Well, some can be in lower education, although the Supreme Court has made that also increasingly difficult to do legally, but trying to integrate schools in various ways. And then one example is in Northern Virginia right now, the Thomas Jefferson School changed its admission standards from a very rigorous test to one that gives a lot of weight to whether it's a high school that hasn't been represented there very often, whether it's low-income family, whether it's English is a second language in that family. And that's a way to increase the percent of Black and Latino students at the school. There's also programs designed to kind of college prep. We actually have one this summer at the law school called Roadmap Scholars, where we bring in essentially first generation people who've never gone, no one in the family's gone to college before, and now they're in college, and then if they're interested in law school, they have to apply and write an essay and the like, and have letters of recommendation, and then we bring them in about a dozen for a month, and they take law courses, and then this year, the second year, they're coming in to do what they call kind of law school application boot camp, where they're going to fill out applications to law school and then intern with some company for several weeks over the summer. And there's a new crop coming in that will be their first summer. And then outside of education, there are, like in the employment context, affirmative action, say in hiring or promotion in occupations like police, firefighting, construction, business loans, government contracts, are contexts in which affirmative action has been used.
So where does affirmative action stand right now from a legal point of view? My understanding, pretty pivotal case in the late 70s that defined how we think about affirmative action. It's been guiding things for the last couple of decades. But where does it stand right now?
Yeah, good question. So it's been fairly stable for the past 45 years since a case called Bakke versus University of California Medical School at Davis, in which the Supreme Court held that you could not use a racial quota. They had 100 seats to the medical school, and they set aside 16 for 4 racial groups, Black, Latino, Asian, and Indian. And the Supreme Court in a 5-4 decision struck down the use of the quota, but said you could use race as just a factor without having a fixed number of people you're trying to admit, and could do so to achieve a diverse student body. And that's been the law ever since. There was a case in 2003 involving the University of Michigan where many people thought the court was going to prohibit using race because of the change in the composition of the court. It became more conservative. But again, in a 5-4 decision, the court upheld using race as one factor. They say it has to be a holistic review, which means you don't just look at race, but you consider race along with a variety of other test grades, letters of recommendation, other activities. And so long as it's just one factor, the court continues to allow it. They thought it would be eliminated again in 2015 in a case against the University of Texas, but conservatives keep moving slightly left. So O'Connor moved left in Magruder, the Michigan case, then Kennedy moved left in Fisher, upheld affirmative action. So its demise has been expected many times, but it's survived. And what the court does is it applies a test called strict scrutiny to decide whether the use of race is constitutional. And it says there are 2 questions the court asks. One, is the purpose for taking race into account compelling, meaning very important? And what counts as compelling is a very small list of purposes. And then even if it satisfies that question, then the court asks, are you using race in a narrowly tailored or necessary way? And that's several factors the court looks at. If it's a quota, it's not considered properly tailored. If it's a fixed number of points, which happened in a college case in Michigan, that's not narrowly tailored. It has to be, if there are race-neutral alternatives that would achieve the same racial diversity, then it's not considered narrowly tailored. So it has to be, race is necessary, and it's used in, again, this sort of one of many factors way. So that strict scrutiny test has been applied, and with dissenting opinions has continued to uphold affirmative action, which leads us to the cases before the court right now.
So strict scrutiny, it's got to have a compelling interest. There has to be a compelling interest, and this has to be the only way that you can achieve those interests. Okay, those are the two.
Exactly.
Let's step back before we jump to these cases, because I think it might be related. The Bakke case, you mentioned diversity was the goal. What was the argument that the Supreme Court made in that case? Why is diversity in our educational system important? Why does it matter? And how does that connect to issues of justice and responding to, in particular, the legacy of slavery and segregation in our society?
Yeah, that is a good question, and I frankly find it disappointing that diversity has become the main purpose that the court allows. In theory, the court has recognized two purposes for affirmative action. One is the benefits of having a racially diverse student body, and to your question why that's important, the court in Bakke talked about mainly the kind of academic benefit of having different perspectives, and that race and culture helps bring in different kinds of perspectives, and that contributes to the search for knowledge and engagement in the academic context. In the Grutter case, Grutter versus University of Michigan, the law school case in 2003, the court added some other considerations. In addition to the exchange of ideas, the court also said it helps to essentially improve cross-racial understanding, which is a kind of social benefit, and then also it helps prepare students to work in a racially diverse workforce. It also cited briefs by major corporations and military leaders saying that we need highly educated, diverse people to work in corporations and serve as officers in the military to help the functioning of those institutions. And then the final point the court made in Grutter was it creates political legitimacy for society to have places of leadership visibly open to all racial groups, is the way the court put it. So those are kind of a variety of benefits the court has noted for diversity. And they tend to be a priority in higher education. That kind of concept tends to have less appeal when you talk about diversifying a construction company. Whereas the other purpose is remedying racial injustice, which would cut across all segments of society, wherever there are significant inequalities that are likely produced by our history of discrimination. And in Bakke, that was one of the reasons the University of California put forward, and there were 4 justices that agreed with them that remedying past discrimination should be the justification. But in a series of cases involving government contracts and some other contexts, the court has made satisfying that rationale too difficult. For the tailoring, it says you basically have to make sure that the people you're benefiting, you can prove were discriminated against in a way that makes them need a racial benefit. And that's just
remedying past injustice is not actually one of the legal justifications for affirmative action, as it stands right now.
Correct. So, and in fact, in these cases, the schools affirmatively deny that that's what they're trying to do, because they know that if they get stuck in trying to satisfy that test, they wouldn't allow. In fact, Michigan had an interesting argument. They say, one of the reasons we're using race is because of discrimination, but we're not trying to remedy the discrimination. We're seeking the perspective that comes from experiencing discrimination, and that then contributes to diversity.
The ideological diversity. Okay, so that's been the status quo up till now. We have these 2 cases at Harvard and UNC. Tell us what's going on with these cases. What are the arguments that are being put forward on both sides? And maybe if you want to, what do you think is going to happen?
Sure. These are cases that have been organized by a conservative activist named Edward Bloom, and he has been working towards ending affirmative action. He actually sponsored the case against the University of Texas by Abigail Fisher, which the court upheld affirmative action, but many people thought it wouldn't. He also sponsored a case that you may have heard of called Shelby County versus Eric Holder, in which the Supreme Court invalidated portions of the Voting Rights Act. And essentially, he decided after losing the Fisher case that an argument that he wanted to bring, and I'm not disputing his sincerity, but was to bring a case on behalf of Asian applicants, as opposed to all the prior cases, Bakke, Gratz, Fisher, they all involved white plaintiffs. So he sought and organized a group called Students for Fair Admissions, or SFFA, and it represents people who applied to Harvard and to UNC Chapel Hill who are of Asian ancestry and who were rejected. And so they're suing, claiming that they were discriminated against in violation of the Equal Protection Clause of the 14th Amendment. And both cases make two general claims. One is that both UNC and Harvard are violating existing law, existing precedents. So that the strict scrutiny test that has allowed a mild use of race to achieve student body diversity is being violated. So court, you don't even need to change the law. They're currently in violation of the law. And if they win on that argument, then UNC and Harvard would have to change their policies, but other schools could continue as long as they're still complying with the past precedents. So the first claim is they're violating existing law. The second claim, which I think is their more important claim, and why Ed Bloom is sponsoring this litigation, is that even if they're complying with existing precedents, those precedents should be overruled, and the court should just ban all uses of race no matter what. So that's their ultimate request. The two cases are mostly similar, but the UNC is easier to describe, so I'll start with that one. Their argument for why existing law is being violated is they say that UNC could use race-neutral alternatives to achieve a similar level of racial diversity, such as giving greater weight to socioeconomic disadvantage, being first generation, giving weight to where you graduated your class. More like in Texas and California, they actually have a system, and Florida, where placing in a certain level in your high school class automatically gets you admitted. Right. And that in Texas, for example, the top 10%, that tends to create some racial diversity because there are schools in Texas where they're overwhelmingly Latino or Black. And so the top 10% of those schools bring in Black and Latino students. So they say there are race-neutral alternatives UNC could use, so they're not complying with strict scrutiny. Harvard, the case against Harvard makes 4 arguments about why they're violating existing law. The first is similar, that there are race-neutral alternatives. So they point to the fact that Harvard admits a lot of people, they're called, they're either children of alumni, athletes, or children of donors. I think they're called ALDC, so alumni, legacy, and donor children. And they admit more in those categories than they admit through race-based affirmative action. And not surprisingly, alumni, children of alumni legacies are overwhelmingly white. Children of big donors are overwhelmingly white. And even athletes, despite, you might think of football or basketball, but 70% of people with athletic scholarships to Harvard are white. And a lot of the sports include things like sailing, skiing, lacrosse. So they say if you stop giving a plus to those groups, you would free up a lot of slots, some of which would presumably go to minority groups. So there are race neutral alternatives. Then they say you're using race too much. You're not using it as just a mild factor. It's too big a factor. Third, you're essentially pursuing a racial quota. So they say that from year to year, the percentage of different racial groups is too similar. So you're aiming for a quota, which has been legal since Bakke in 1978. And those three are really affirmative action type arguments. The fourth point they're making is particularly disturbing if it's true, which is that you're actually discriminating against Asians specifically. So where the first three arguments are really more about the plus you're giving to, say, black, brown, and red applicants. This is saying you're actually targeting Asian applicants and treating them even less favorably than white applicants. And so they're claiming that there's a personality score. And they say that the personality scores for Asians are on average lower than all other racial groups. So they say that there's some sort of racial bias or stereotyping going on where if they're Asian, they're not, the claim is it could be coming through, they rely on kind of alumni interviews with applicants, letters of recommendation from teachers and counselors at the high school. So it could be from a variety of perspectives, but that Asians are less likely to get strong scores on leadership or outgoingness or confidence.
So Kim, are you saying that there's a quantified score that's being used for admissions? That's the claim, at least, at Harvard?
Yeah, and that's undisputed.
Oh, that is undisputed,
Yeah,
okay.
but when Harvard
So if
denies
somebody
that-
gets, 10 points or whatever for leadership or whatever, that's how they total it up and figure out who should, okay.
Yeah, they look at grades, test scores, letter of recommendation, alumni legacy, things like that, and personality.
Okay.
And then that violates existing law, not so much because it's not complying with affirmative action, but just it's not even considered affirmative action.
Right.
To discriminate against Asians, that's just illegal discrimination. Now, the trial courts, both cases went to trial, and the trial court heard evidence, statistical evidence and testimony and records, very extensive litigation, and the trial courts in both cases found for the universities and said that there was no discrimination against Asians, at least the case wasn't proven, and the use of race was complying with strict scrutiny. And then the Circuit Court of Appeals in the Harvard case looked at the record and also ruled in favor of the university. The UNC case was never decided on appeal because they petitioned directly to the Supreme Court when the court took the Harvard case, and the court took that case as well. So that really sets up where it's normally trial court findings of fact are given a lot of deference by appeals courts because they see the witnesses and the like. So it would be surprising if the Supreme Court would overturn what the trial court found. So if the court wants to keep the law the way it is, then they would probably say, if the trial court says you're only using race in a small way, you're not discriminating against Asians, or are not adequate race-neutral alternatives, then we would affirm. But the fact that the court took the case, both cases, suggests that the court wants to do something bigger. And so...
change the status quo.
Exactly. So I think most people predict that that the court will actually change the law. And it could change it just to be even stricter. So where like race neutral alternatives like legacies or socioeconomic disadvantage really have to be exhausted before you consider race. You have to kind of change all other elements of your admissions program if that might help, which would go, I think, beyond what's current law. But a lot of observers think the court will just say, you can't use race at all. So impose what the metaphor is to impose a rule of color blindness, that the government has to completely ignore race.
Let's step back for a moment too and think about the issue of remedying past injustices. If you were an enlightened dictator and you could set the law, right? There wasn't a Supreme Court. You were the Supreme Court. What do you think our law should be with regard to remedying past injustices? How should it be structured? What do you think would be just and fair and in line with the values of our nation? So let's start with that. How would you develop the law?
That is a tough question because
we only ask tough questions.
Because it really is a difficult problem. And
let's imagine maybe we go back and say, let's say the Bakke case was decided differently, right? And it was flipped. It was the other way. What do you think schools should be doing in the Constitution?
Well, let me start by, if I assume I had the knowledge of God, but in this case, I will not be so presumptuous. But if we had perfect knowledge, what's the goal? The goal would be to, in some ways, remedy, alleviate, compensate for the extent to which people of color, especially Black and tribal Indian, are materially worse off than they would be had our history been more just, or if it had been corrected, stopped and corrected sooner. The challenge is we don't have perfect knowledge, and so even though there's statistics that show huge disparities in wealth and educational achievement and employment and poverty and crime victimization and crime commission, it's hard to know to what extent in which people are experiencing that disadvantage because of racial injustice. So anything that happens is going to be imperfect. But my point is that rough justice is better than no justice. And if we require some sort of perfect solution, so the strict scrutiny test, for example, for remedying past discrimination, it's impossible to satisfy because they're requiring information that you can't have. And the reason we don't have the information of how much what particular people have been discriminated against or past generations have been in ways that affect them is the fault of America. We discriminated against Black and brown and red people for hundreds of years comprehensively, without documentation. And then we say, okay, well, if you can prove who we discriminated against, we'll listen to your case. Well, you, America, and I'm part of America, you're the one who's made this as difficult as it is. And to do nothing is to leave injustices unremedied. So I would begin with, we have to accept a degree of imperfection. Some people will be benefited more than perhaps they deserve in an ideal way. And then I would want it to try to get at problems that continue over generations. So I'm very skeptical of monetary reparations because, frankly, one of the effects of oppression is people don't have the education and wherewithal and to build for future generations. So I would want it to focus on like education and wealth accumulation, property accumulation, job training, things like that, things that would help to
multi-generational system.
And women would be key. It turns out, except I mentioned this in class the other day nervously because it sounds sexist, but if you want to have for future generations, it's better to put money in women's hands. And it turned out that a student in my law school class, she worked before law school for, I think it was the International Monetary Fund, and she said that a lot of money that's donated for developing countries actually limit who can receive it to women. They're more likely to spend it on education for their children and the like. So
investments.
Yeah. So anyway, and then I would, at least because I focus more on constitutional law, which is about what can society, what are we allowed. I will acknowledge that I don't have a lot of expertise on the what to do or the how to do it, but the court should, with some scrutiny, I don't think race should be allowed to be used without some accountability, but should prefer more than it does to allowing good faith efforts to improve opportunities for people.
And you feel all that would be in line with the 14th Amendment, Equal Protection Clause, and would be violated? So that seems to be like the heart of the matter, right? What violates that clause, what doesn't?
Absolutely. I mean, equality is a very capacious term and can mean a lot of things. And even if it doesn't even necessarily mean that you shouldn't ever discriminate by race. It's how race was used that was wrong, not just that race was used. But also, even if you say, well, generally race shouldn't be used, well, then what do you do when it is used in an invidious way? Then it becomes necessary to take race into account to correct that. And you see that in affirmative action cases when students for fair admissions bring their lawsuit, they identify in their complaint that they're Asian. You see this in the other cases too, like Barbara Gruder identifies herself as white and representing a class of Caucasian applicants to the University of Michigan who were denied admission because of their race. So they identify along racial lines and as a group. So when critics of affirmative action say, government should be colorblind and treat people as individuals, well, you want to be treated as a member of a racial group when you want what you view as discrimination, the remedies, because you have to determine whether you've been discriminated against. You have to know what your race is. So when we have hundreds of years of the worst kind of discrimination, by far, way worse morally and in harm to what affirmative action does, you have to take race into account to correct it. And so I would say not only should be allowed by the Equal Protection Clause that government get to take race into account to remedy racial inequality, certainly from a moral perspective, it's required. There should be a duty to correct the discrimination that we as a society engaged in for so long.
All right. Well, I think that's a helpful framework for thinking about this issue. I appreciate all of that, Kim. Let's open it up to questions. I'm sure there's some questions in the group. Yes?
Hi. I graduated from law school about 10 years ago, so kind of firmly during the Obama administration prior to Black Lives Matter and just the rally here and critical race theory of Florida and all that stuff. So I was wondering, compared to maybe when I graduated or prior, how have you seen the discussions in your classes? Like, what's the tenor of, what are the students saying now?
Thank you. Yes, I think it's had an effect. When I started in 27 years ago, 96, and then say over the next 10, 15 years or so, I would say support for affirmative action was going down. And it's interesting that initially in 96, there was moderate support for affirmative action and weak support for like same-sex marriage. Even a lot of Democrats were against it. And then over time, I think affirmative action support has been going down, and support for gay rights and same-sex marriage has gone up. We're on a graph, I think of them as like passing each other. And then it got to where maybe 5, 6, 7 years ago, I was talking about affirmative action and realized that even people who were supportive of affirmative action weren't mentioning history at all. They were just talking about the forward-looking benefits and how this would help our society and things like that. And I was really puzzled because, to me, the original justification for affirmative action, and I think the one that many people, including myself, think is more important, is remedying a history of racial injustice. But it's like people didn't think of it that way. And I remember, kind of pathetically saying, "Does anyone care?" to my class. And but it's come back up, and I think in response to the Black Lives Matter movement, not just George Floyd and Breonna Taylor, but even I co-authored a casebook on racial justice, and casebook takes many years, and so it's like each year I have to substitute a new example to make it sound current. Okay, it was Trayvon Martin, and it was Michael Brown, and just year after year after year, Black people in the news for what appeared to be unjustified killings. So I think support has definitely gone up, and schools are taking notes, so you really see a kind of divide where on the one hand you have schools like, our governor, and especially like Florida and other places saying, let's ban critical race theory, which they just mean racial history. They really don't know what critical race theory is, and that's not really their target. But then at the same time, you have a lot of schools increasing race-based course offerings. And in fact, the American Bar Association, starting this fall, it's required that every law school to be accredited has to require an educational experience, actually 2, during the life of the law student's tenure at law school that exposes them to issues of racial bias and cultural competency. So some people are trying to reduce the amount of race, but certainly among progressive institutions and progressive states, you can really see a greater commitment to discussing race.
Yes, back there.
Hi.
Yes, back.
Hi. So I'm not a lawyer, but it's been my loose understanding that the Supreme Court overall historically has not been the kindest to the 14th Amendment, starting with, I believe, the slaughterhouse cases. And I know that in the Dobbs decision, the Supreme Court just said, equal protection, what's that? So do you think that the current composition of the court would have given any pause to have, thrown out chunks of equal protection in the Dobbs decision, but then cited to do what they want here?
I'm sorry, can you repeat the last part of the question?
So the Supreme Court just said, it basically jumped a big chunk of equal protection as applied in the Dobbs decision. Do you think that the current composition of the court would have any pause, given that it seems like they have a set outcome in mind as they're heading into this trial? Do you think it would give them any pause to jump equal protection under Dobbs, but cite it here as something valid and valuable to achieve the outcome that they are interested in?
Kind of using the 14th Amendment when you want a certain outcome, one way or the other.
Yeah, I can no longer predict the court, which makes it difficult. I don't know what practicing lawyers are supposed to do when they advise clients, because you're supposed to be able to anticipate what the court does based on what it said. Well, Dobbs, a mild correction, jumped due process rather than equal protection. So it said there's no longer a right to abortion. And I was actually just been reading it this weekend because we're talking about it on Tuesday. And we just finished the Second Amendment case where the court expanded the Second Amendment rights. And the court is now just originalism, what the original understanding of the Constitution was, looking at history. It's just weird that now in class, instead of talking about things in our society as we live in it today, we're talking about things like what does it mean to bear a lance? And does the constable have the authority to, take a musket from a law-abiding, member of the local township or something? And it's like reading kind of 1700s history to decide what we're allowed to do as a society today, which doesn't make a lot of sense. Like it says, the Second Amendment, weapons in common usage at the time. And you can only restrict gun ownership to the extent that you can show that regulating that kind of weapon was common in those days, but there weren't assault weapons. So we're saying we can't regulate assault weapons today because you can't show that there's a tradition of regulating assault weapons. So with affirmative action, they're opportunistic. I always caveat that say, liberals do it too, but maybe I'm more sensitive to when conservatives do it because it hurts what I think is the right way to go. But so people like Justice Thomas and Scalia and the conservatives have been pushing for years, and they now have a supermajority of 6, to say, the Constitution does not evolve. It's fixed at the time it's enacted. And that's all the rights that you have, is what were fixed at the time of either 1791, the original Bill of Rights, or 1868, the 14th Amendment. And so, any rights since then, like gay rights or same-sex marriage or abortion, are not protected. Scalia would say also women's rights. So if at least they were consistent, they should actually uphold affirmative action. Because whether you think affirmative action is good policy or not, the evidence of when the 14th Amendment was enacted was that it was principally designed to equalize the condition of the former slaves. And in fact, the slaughterhouse cases you mentioned said they rejected an equal protection claim in an economic context and said, we don't think any equal protection claim that's not brought on behalf of Negroes would ever be recognized. So, and that was within a decade of the 14th Amendment. So they're talking about this amendment was to uplift the condition of the Negro race. And the Reconstruction Congress, the 39th Congress during Reconstruction, after passing the 14th Amendment, which now is being read to say you can't take race into account, they then passed laws to benefit the freed slaves. And some of them were focused just on whether you had been a slave, but some were focused by expressly in racial terms. Like poor black mothers and children in the District of Columbia were given benefits, or pensions for black soldiers. And it said, black and Negro soldiers didn't say who had been former slaves. So it was race-based. And that was argued before the Supreme Court this term. And people like Justice Thomas, who's the most insistent on originalism, never provides an originalist argument. Neither did Scalia. They just said affirmative action is wrong. And so, but I thought you're supposed to say, as you do with things like abortion and women's rights and gay rights, it's not our job to decide what's right or wrong. We just enforce what the original understanding of the Constitution was. Well, why don't you do the same thing here? It's not our job to decide whether affirmative action is right or wrong. It wasn't forbidden by the 14th Amendment. Justice Amy Coney Barrett, who's conservative, actually said at oral argument, it looks like the historical evidence allow for remedial affirmative action, meaning to remedy inequality. But then she said, but not for diversity purposes. And then she says, and we can't allow the remedial because our precedents don't allow it. I'm like, what do you mean? You just overturned 50 years of abortion precedent. Since when do you care about precedent? And now you're saying you can't honor the original understanding of the 14th Amendment? You can engage in remedial affirmative action because modern precedents don't allow it? We talk about hypocrisy. And in fact, I just wrote an op-ed that I'm going to try and place that makes an additional point. States also engaged in race-based preferences immediately following the 14th Amendment. And they were quotas, in fact. They were that you have to be 100% white. And that was done from the time of the 14th Amendment until the Supreme Court started requiring admissions of black people in the mid-20th century. So the federal government and the state governments assumed that some attention to race was perfectly lawful. So it's inconsistent to now ignore history when you're applying the Equal Protection Clause, when you made history everything when you're talking about liberty or Second Amendment or free exercise of religion, for that matter. The case last year that upheld a high school coach praying at the 50-yard line, the court overturned another precedent that required more of a separation between church and state because he was a public school teacher on the job at the time. It wasn't in a private context. But so the court now has made long-time tradition in history the coin of the realm. Realm's another term I've been learning. Except when it comes to affirmative action. And then they just stick to it's unconstitutional, the Constitution is colorblind, but they don't cite any historical evidence to support that.
Very interesting. Yeah, let's do one last question right there.
I'm going to try to make this not a discombobulated mess in my brain. So, given that first, let's parse the difference between, let's say, the common man or the street, and students that are coming out of Harvard and UNC Chapel Hill, which is directly headed for the boardroom, right, in theory. In practice, there's some interesting intersectionality between technology and authenticity that is being the courts are being leapt over every day by technology. Privy to some people that are using ChatGPT to respond to RFPs, requests for proposals, at the governmental level. The old aristocracy looks really a lot like the new aristocracy, just with one or two Latinos on the board. And you see a lot of this happen. We just led a $300 million contract based on SIPR, small business incentive, which is largely for 88 companies. The application of the law and affirmative action seems to allow the old system to stay in place with some nominal or notional glance in that direction. And it seems like authenticity is something that is inherently lacking in our system, given that we're like the 17th most corrupt nation in the world. How do we, it makes sense that you want to put the thumb on the scale, but the application of the law, at least at the federal level, and I don't really think that these cases are, or maybe these cases are bellwethers for larger things, right? So I just mentioned a $300 million contracting action I was part of, and that's just one of dozens that happen every year. Is it really a grab for the money at the higher levels of government and how federal contracting works, as opposed to some students being let into school? Because there is a much bigger compendium of casualty that will happen based upon these findings. That's what I see or believe.
Are you also asking, in a sense, whether it's really making a difference, whether
Yeah.
affirmative action is actually changing some of these systemic issues in our society?
So then the question is, what about meritocracy? What about, the other side of the argument is that these shouldn't be causal factors. If you have a way of removing those modes in the distribution for selection, and of course they're probably using some sort of linear algebra to figure out whether or not you get into school, If those are not correlated factors to success, then if you don't include them and you show that you don't include them, this dragging artificial intelligence into this as well, with training sets on race and how to recruit biases in our selection algorithms. If you do, in fact, move towards meritocracy, are you not also meeting the ends of affirmative action without having to declare that?
Few general, this will have to be our last, I know it's a big question, but a few general thoughts.
I think you lost me in linear algebra.
No math, yeah.
Yeah, so I'll try to be, so first on whether it's doing a lot. Yeah, I think affirmative action in the news is the affirmative action at elite schools of higher education where the students would likely do fine even if they're not admitted to those particular schools. But my concern is the formality of the law is that when you say you have to be colorblind in this context, then that extends to other contexts, including, for example, trying to improve the quality of urban public schools. If you're doing it with a kind of eye towards the racial gap between certain schools and other schools, that becomes more difficult if the court says you can't use affirmative action in elite schools. So I do worry about more the breadth of context where the need might be greater. In terms of if there's greater meritocracy, yeah, I think that helps, but it only goes so far. And which is to say, even if you could kind of weed out bias and even take like legacy admissions, those aren't particularly related to merit or being a donor's child. So whether you call that corruption or not, they're not particularly merit based. So there's a lot of taking emphasis, changing processes to be more merit based. I think would help to weed out some things that tend to exclude people of color. But it would only go so far because the lower quality of opportunities that Black people and other people of color on average are born into means that by the time, say, they're young child even, but throughout their growing up, they're not getting the opportunities to be educated, both because of the schools and because of their parents don't have the same education in their background, etc. So that they aren't on average have as much skill and qualifications. So at some point, if you're going to correct for racial inequality, you kind of have to have some thumb on the scale that even maybe is going counter to meritocracy. You see this in disparate impact, which is a doctrine that says if like a job qualification tends to have a disparate impact against a group, whether it's say women or people of color, then you have to demonstrate that it's truly related to the job. And that has helped to root out many meritorious qualifications. So that's helped to increase, without having to use preferences, how many women and minorities get admitted to certain jobs. But it turns out that there are jobs that really do predict people who have the skills required for the job that are still then going to have a discriminatory effect along racial lines. And so just limiting things to merit, I don't think would go far enough. Thank you.
Thank you, Kim. If you have some other questions for him, if that's all right. Go in peace to love and serve the Lord. Thanks for the